In this class we're going to look at acceptance in the context of the law of contract. You'll appreciate that there are essentially four elements in contract: offer, acceptance, intention to create a contract, and consideration. Well, we're dealing with acceptance. So an offer has been made, let's say. If it's accepted and if the other two conditions are met, then a contract would come into existence. Now, as soon as an offer is accepted, a contract comes into existence and both parties are legally bound. That's assuming that the other two conditions are met. An acceptance can be made by words or conduct. It doesn't have to be written. So it could be a verbal acceptance, or it could be indeed the behavior of one of the parties suggests that they accepted. Now, there are two types of contract. One is a unilateral and the other is a bilateral. With a unilateral contract, there is only one party to the contract who makes the offer to the world, let's say. Now, the acceptance must be communicated to the offerer, and the contract is not completed until this communication is received. The case here is in Tories versus Miles Far East Corporation, 1955. This was a Queen's Bench Court of Appeal case. In this case, essentially the claimant wanted to buy some cathodes, 100 tons of cathodes, from the defendant in Holland, and they sent telexes to agree the terms of the contract. The problem for the court, and the problem at issue here, was at what point did the contract come into existence? If it came into existence, if the acceptance was deemed to have been in Holland, then Dutch law would apply. Or if the acceptance was deemed to be in England, then English law would apply. So where did it happen? Well, it was held by the Court of Appeal that to amount as an effective acceptance, the acceptance needs to be communicated to the offeree. And therefore, the contract was made in England. The offerer in Holland sent a telex to England stating the conditions. So the offeree received that, and they received it in England, and that's when they accepted. So it was English law that applies. Now, the second type of contract, the bilateral, means there are two parties to the contract. This is the usual case. And this is only effective when it is received rather than when it's sent. So an acceptance in a bilateral case comes into effect when it's received rather than when it's sent. Now, not an acceptance. Well, there are cases when what looks like an acceptance are in fact not an acceptance. A person cannot accept a contract by saying nothing or doing nothing. Established in 1862 by the Feldhaus-Brindley case. Silence does not constitute an acceptance. In the Feldhaus case, what happened was a nephew wrote to his uncle to buy a horse, and said in the letter that if I don't hear from you by the weekend, I will consider him mine. I will consider the horse mine. The horse was then sold by mistake, and a court case followed. Now, what the court had to decide was, did the uncle and the nephew have a contract? Well, they decided that there was no contract because the uncle had not responded to the nephew's letter. The nephew wrote to the uncle saying, unless I hear from you by the weekend, I will consider him mine. But the uncle didn't respond to that. The uncle was silent. So there was no contract. Silence does not constitute acceptance in a contract. Acceptance of an offer must be unqualified and unconditional. So the material alteration of the terms of an offer amount to a counter-offer, and so revokes the original offer, not an acceptance. The case here is Hyde and Wrench in 1840. This was a case that went before the Chancery Division. What happened was the defendant offered to sell a farm to the claimant for £1,000. The claimant in reply offered £950 and the defendant refused. The claimant then sought to accept the original offer of £1,000, but the defendant refused to sell to the claimant, and the claimant brought an action for specific performance. Now it was held by the Chancery Division that there was no contract. Where a counter-offer is made, this destroys the original offer, so that it is no longer open to the offeree to accept. So, if a counter-offer is made and rejected, the original offer is no longer available. And also, the request for information does not constitute acceptance. This was an 1880 case between Stevenson and McLean. In this case, the contract had gone through. The contract had been agreed, but the McLean wanted clarification of some points of the contract, and that was all they wanted. So it was a request for information and did not constitute acceptance. So the contract had not gone through. It was just a question of clarifying what was meant in the contract. But that request for information was not acceptance of the contract. So there was no contract. There was no contract because it was just a request for information. An interesting side to all of this is what's known as the Postal Rule. This is an exception to the need for actual communications, and this was originated in the Adams versus Lensell case of 1818. What it does is it establishes the principle that a letter, when posted in the postbox, that is the point at which the contract comes into existence. So it doesn't have to be received, it just has to be in the postbox. And that court case established that principle. If the rule applies, then the acceptance is only effective when the letter or telegram is posted, not when it's received. So that is the rule, the Postal Rule. The Postal Rule still applies even when the letter of acceptance was permanently lost in the post. So once it's posted, the contract is in place. And if it gets lost in the post, the contract is still in place. The letter of acceptance must be properly posted and not handed to the postman or to someone else to post. It must be posted properly in the postbox. This must also, of course, be the agreed form of communication between the parties. They must agree that the post is the agreed form of communication. And of course the letter has to be correctly addressed and carry the correct postage stamp. And also posted, as I said, in the postbox. That's the postal rule. So contracts can be accepted by post if that's agreed between the parties, and if the letter is properly addressed and carries the right postage stamp, and at the moment it's put into the postbox, that's when the contract comes into existence. It doesn't apply in cases of acceptance by letter or telegram always. It's not always the case. For example, the postal rule was excluded in the case of Howell Securities versus Hughes in 1974. In this case, very briefly, Dr. Hughes granted Howell Securities an option to purchase his house for £45,000. The option was to be executed by notice in writing within 6 months. Now, 5 days before the expiry, Howell posted a letter exercising the option. The letter was never received by Hughes. However, Howell sought to enforce the option, relying on the postal rule, stating the acceptance took place before the expiry of the option. However, it was held by the judges that requiring notice in writing, which is what Dr. Hughes required, notice in writing, had specified that he had to actually receive the communication and had therefore excluded the postal rule. So it is possible to exclude the postal rule if it's explicitly stated. In other words, if they want it in writing and it must be communicated in writing, then that means the postal rule may not be applicable. There was no contract because the term notice in writing, which expressly stated that an acceptance had to reach the offerer. It's important to remember that the rule is confined to acceptance by letter or telegram and is very much alive despite the Howell Securities versus Hughes ruling. That ruling is almost an exception. It just simply states that in that case Dr. Hughes wanted it explicitly in writing and it had to be communicated to him in writing. He must have received it within the time slot, within the 6 months. And since that did not happen, the postal rule did not apply. But generally speaking, the postal rule does apply. Now in auctions, well, acceptance in auction takes place when the auctioneer's gavel hits the table. When the little gavel the auctioneer uses hits the table, that's when acceptance takes place. Until such an acceptance is made, any bid can be withdrawn. So until the gavel hits the table, a bid may be withdrawn. As soon as the gavel hits the table, a contract is formed and the highest bidder has bought the lot which is up for sale. So it's when the auctioneer's gavel hits the table, when he strikes the table, that's when the contract is made. This is actually written into statute law, and Section 57 of the Sale of Goods Act 1979 regulates the law relating to acceptance at auctions, and this was based on 2 further cases. But that's what it's based on. Now, for tenders, well, both goods and services can be bought or sold by tender method. This is particularly favoured by organisations such as local authorities. Tender simply means the local authority asks for bidders to do a particular task, to undertake a particular job. And depending on the conditions set out by the local authorities in looking for the tenders, a contract will come into existence once the tenders have been selected and an agreement has been made between them and the local authority. At that point, a contract can be drawn. But notice of tenders normally appears in newspapers, quality newspapers, inviting companies or suppliers to tender for a job, to apply for the work, give a bid and set out how they're going to approach doing the job and why they're qualified to do the job. And after scrutiny of the various tenders, the local authority, let's say, will select the one most appropriate, and at that point a contract may be agreed between them. So these are some ideas and some notes about acceptance in a contract and looking at some of the issues in acceptance of the contract. You will find a lot of case background here in the notes, in the slides that we've just looked over. I suggest you go back over this set of notes, make your own notes, and check out the various cases online. You'll find a lot of information about them. If you just type in Howell Securities and Hughes, you'll find a lot of information about the case. So you can pad out your own notes and get a greater understanding of what was meant in that case. So there's a lot of material online for you to use in building up your knowledge of acceptance in contracts. But for the moment, that's all I want to do here, so thank you for watching.